this decision could affect even regular search warrants.
Yeah, it's possible. So one of the reasons why this decision is so disappointing is because it creates a conflict between with an earlier appellate court decision by a different district that involved actually the investigation of Michael Jackson. And so what the court in that case said was that the public did have a right to access search warrant affidavits. There was an affidavit at issue there, but that in that specific case, the concerns about some of the materials contained and whether it could be withheld required that affidavit to be withheld. Basically, the concerns overruled the presumption of the public's right to access court records. What the fourth district said in our case was actually that the public doesn't even have a presumptive right to these records. And so it creates a lot of confusion in the law throughout the state as to what rule court should follow. Do they follow the rule that the court announced in People versus Jackson, or do they follow now the rule that this court announced? And ultimately what that means is that it's a loss for the broader public because of this ambiguity as to whether or not the public has a right to access search warrant affidavits. Of course, there's a way to argue, and we would argue that the San Bernardino decision in our case is limited to search warrant affidavits that contain Hobbs material or other sort of privileged material claimed by law enforcement. But the decision itself is not clear in drawing a line between that, whether or not it applies narrowly or whether it's a broader sort of impact on the public's right of access to all search warrant affidavits.